Hey, this is Mike Diercksen from Proactive, and you're listening to the Building Byte podcast. Tune in as we spotlight our guest, Theresa Guertin, partner and member of SDV Law's Management Committee in Trumbull, Connecticut. Our episode today is focused on the evolving landscape of construction insurance. For more information on this episode and others, please check out the Building Byte at www.buildwithproactive.com.
Welcome to the Building Byte podcast, a podcast for construction contractors, owners, and insurance professionals, where you'll hear from the experts about key topics to help you remain successful. I'm Chris Epps, a vice president at Proactive, and I'm joined here with my co-host, Mike Diercksen, our manager of marketing and business development. We welcome our guest today, Theresa Guertin. Theresa is a partner and member of the SDV Law Firm's Management Committee in Trumbull, Connecticut. Theresa, how are you doing this afternoon?
I'm great, thanks. How are you guys?
Doing wonderful. Well, jumping right in, Theresa, pleasure to have you on the show. Before we dive in, I was hoping you could give our listeners a little bit of your background on your career path and kind of what led you to managing partner at SDV Law.
Sure. Yeah, sure. Well, I started out at SDV as a summer associate, which is basically an intern in between your second and your third year of law school. And I've been there ever since, which is a little unusual these days. You know, like most industries, people jump around a lot, but I found a home early and I was lucky. So I've been there now. This is my 16th year at SDV. And I started as an attorney, worked my way up to partner. I was managing partner, like you said, for a couple of years. Now I'm on the management committee, which is sort of a different thing. It's internal law firm jargon, but essentially I do both management of the firm and litigation and all of our legal services as well. So it's a busy life, but I like it.
Yeah, Mike, I think Theresa gets a gold star for shortest career path. They only had one turn.
I spent many years before that bagging groceries and serving drinks at bars, but that was a different life.
There you go. Yeah, certainly the rarity these days to find a spot and stick with it, and grow into that. So that's awesome, Theresa.
Yeah.
Well, driving right into today's topic, which is a focus on case law and evolving landscape of construction insurance. Theresa, there's been some significant cases recently, and I think our audience, primarily contractors, risk managers, brokers, carriers, it's something that they're aware of, but maybe not as in depth as they need to be. So, with the industry at large, before jumping in, could you give us a quick overview on why you think it's important for these stakeholders to kind of keep tabs on these major cases?
Yeah, absolutely. I mean, I've got 3 for you guys today that we'll go over. And essentially, the message is the same. You have to keep up with what's going on with the court cases in order to know how to adjust your planning. Courts take a long time to get to these insurance coverage issues. Usually it'll be 10 years post a policy being issued that something is litigated. And things evolve, courts take different approaches. So it's really important to stay on top of these developments because you might decide that you need to change your policies or change your process for vetting subcontractors or, change wording in your contracts. And if you don't do it, your competitors are doing it or your insurance company's keeping on top of it. So you could get in some trouble if you don't pay attention.
Yeah, there's no do-overs, right? It's not, oh, I thought it was something else. It's, you got to make sure you're dialed into that.
Yeah, absolutely.
Well, Theresa, I know one of the notable cases we've heard plenty about recently and has gotten a lot of publicity, at least in our insurance-related circles, is South Capitol Bridge Builders v. Lexington, and this one associated with Leg 3 coverage. Can you share with our audience a brief overview of the case and the results of that ruling and maybe how that's, going to impact things going forward, as you suggest, how that kind of changes how we do things?
Yeah, for sure. I mean, this is actually a really good case for policyholders, which is nice to be reporting about for once. But essentially, this is a builder's risk case. And it all boils down to what is the burden of proof? Insurance companies have been taking these aggressive positions with respect to builder's risk cases and saying that the insured, the policyholder, can't prove that the insuring agreement has been triggered, meaning they can't show that there was all risk of direct physical loss. if there was faulty work on the project to begin with. And this is the so-called satisfactory state argument. This is something that came up. They kind of cribbed it from a really old case. Well, really old. It was from 1990. I was alive. A 1990 case that actually had to do with like auto insurance and an auto incident. And the court was, in that case, they were just trying to summarize or give an example of what does it mean to be physically damaged. And they used this terminology like if it was in a satisfactory state to begin with and then was in an unsatisfactory state, that would be damage. But if it was unsatisfactory to begin with, that wouldn't be damage. But they were talking about a car bumper, is not the same as a construction project.
Mm-hmm.
So in this particular case, the insurance companies have been pushing this argument. They used this argument relating to a construction defect claim for the Frederick Douglass Memorial Bridge, which the concrete had been improperly poured and they vibrate it to make it settle. So it was structurally compromised. And, obviously huge dollars we're talking about. The court basically looked at that and said, this satisfactory state argument is kind of coming out of nowhere. Like the policy language doesn't say that. Is it all risk of direct physical loss? And they said, yes, it is. Because the risk of construction defect or faulty work is a risk that could lead to physical loss. Then they went to the Leg 3 endorsement, which this is what everybody got really hyped about because there's no case law in the U.S. about Leg 3, even though it's been used all over for years and years. And it's actually a really funny part of the decision if you get a chance to read it, because the court just eviscerates the Leg 3 endorsement. They're like, this has, 10 typos, a Scrivener's error, like grammar problems. They're just like, this is a mess, which is true. If you read it, it is such a mess. But, we all in the industry have had an understanding of what Leg 3 means for many years. It's this idea that it's not quite an exclusion. It's more of a limitation to say we're going to cover everything except the cost to improve what was faulty. And again, the carrier here was trying to say that's not what that means. Despite underwriters saying that for years and policyholders assuming that for years, they were arguing again this satisfactory state kind of language. And the court said, after eviscerating it in that fashion, it's really ambiguous. And thus, we need to construe it in favor of the policyholder and find that there's coverage the way that basically the industry has always assumed. So ultimately, really good outcome here for the policyholders because they were able to basically prove their burden on the insuring agreement and they got the benefit of the doubt on the Leg 3 endorsement. So big win there.
Yeah, and it's important because it sets that precedent, right? Like there was nothing before, so now it's not about assumptions that we assume it's going to go one way or another. We have something to base that off of. For sure. And I mean, the way our legal system is set up is that it's not going to be a binding case, on every court in the country. But because it's the only case, you better believe that it's going to be cited and, used by other courts. Like courts, don't want to have to reinvent the wheel. And they would gladly look to a well-written decision from another jurisdiction to save them the brain power of having to sort through a builder's risk policy. So that's, I think, what we're going to see in the forthcoming years. Yeah, so the takeaway here is craft well-written documents, and that way you don't get eviscerated in court and lose that standing. Yeah, exactly. Well, another case that came up was the New York City Housing Authority, or NYCHA, with Harleysville, Worcester, where you see the issue of additional named insureds come into play. Can you give our audience kind of some insight into that and maybe the lingering effects we're going to see? Yeah, so this, in like what's latest bad coming out of New York, I think this goes in that bucket. New York courts have been really tough on policyholders when it comes to additional insured endorsements. And they're not usually wrong, which is hard for us to say, but prior versions of the AI endorsements would say things like, when you and such person enter into an agreement. And the courts have said, well, that's, when you read that grammatically, it means that it is only affording coverage to the entity that's in a direct contract with the subcontractor, what we call privity.
So that had caused a lot of problems like 10 years ago when those decisions came out. The markets adapted. They put out different language to capture all the additional insureds listed on the contract. But now we have this case with totally different wording where the court has said that also requires privity. Mm-hmm. So just to back up a second, we're talking about your standard situation here. Owner, Ocean Hill. They hired GC, Blue Sea Construction, and Blue Sea hires A&R Electrical. A&R Electrical's employee gets hurt and sues the GC and the owner for New York labor law claims, essentially. Mm-hmm. It is a little unique in New York that it happens so often, but that's why we get all this case law. Right. The endorsement they had was the Harleysville standard wording, which said, any person or organization for whom you are performing operations as specified in the contract. So that language, the court said, you're only performing operations for the entity that you're in a direct contract with. So that would mean the general contractor. You're not performing operations for the owner entity, which doesn't make a lot of sense, and is certainly not how the industry thought those words, would be interpreted. So in that case, the owner and a variety of other additional insured entities were denied coverage for that lawsuit from the subcontractor's carrier, Harleysville.
Yeah, I mean, that's definitely an issue for many stakeholders in this process.
Yes.
Specifically upstream, right? You'd imagine with the owners and those parties. So are there ways that they're now looking to change their contract language or gather insurance to accommodate that?
Yeah, well, I think the lesson here is that you still, if you're operating in New York, you've already probably got a contract that's more specific than you have in other jurisdictions about what you can and cannot accept. Now, unfortunately, this for whom you are performing operations has to go on the list of unacceptable endorsements. So, you can modify your contract to be more specific about it, or look at the additional insured endorsements that your subcontractors have to make sure that they don't have that wording in there. Because if they do, especially for GCs, they might be getting the AI coverage because they're in that direct relationship, but now their program has to pick up for all the owner entities. So that's a bummer for them. They want to be passing all that risk down too. So they want to double check those AI endorsements and make sure that all those other AIs are listed either, by name or with broader blanket language.
I love that you're just suggesting that people look at those additional insured endorsements, which seems, as a former project manager, seems like a novel concept starting at ground zero. But
you're giving me heart palpitations.
That's why we need good lawyers.
I do on a day-to-day basis, honestly, is look at people's AI endorsements for them. So
it is definitely a good idea. I'll reinforce that notion for sure. Theresa, I guess finally, and you say you brought three cases to talk about. I'm going to ask you about the third one. In Massachusetts, it's Lawrence Lessard v. Havens and Sons, which is the heart of that issue drives to construction defect as an occurrence under the policy. Can you tell us a little bit more about that one and in the ruling and kind of how that's going to impact things going forward?
Sure. Yeah, this was another case. I was surprised by this one because I feel like the court didn't really do its homework. They were calling this case an issue of first impression in Massachusetts, which is not true. There's other cases in Massachusetts that deal with this issue, and they kind of problematically, they come out all over the board. So it would have been fairer to say this is a issue that has been debated in Massachusetts courts and we don't have firm guidance on. But what happened here, this was kind of a smaller, not a big commercial case. It was a homeowner's case involving, a home builder that built a special house for some people. And it was just problematic in a million different ways, as these cases tend to be, missing structural supports, the flashing was wrong, the windows were wrong, everything was wrong, presumably they found one thing wrong, then they hired an engineer who found 30 other things wrong.
That's how that works.
Yep. But, so we're talking about things like structural integrity, proper insulation, and essentially the insurance company, which is Main Street America, for the GC said the GC doesn't have coverage for this because this is their own business risk of, building homes. They should build homes properly. There should be no coverage for faulty workmanship claims. It's neither property damage nor an occurrence. And they're really kind of focused more on the property damage part of this, but it's a lot of times the courts address these things interchangeably, and they'll one way or another they'll get there and say there's no coverage because this isn't a risk that should be covered by GL. I think it's problematic because that's just not the way the policy is written. And not only that, it's not the way the weight of case law in the country is going. I noticed sprinkled throughout the decision, the Massachusetts court was citing to a whole bunch of older cases or cases from jurisdictions that have since been clarified or overturned or distinguished in some way. So it's a little disconcerting to see that. But basically, they said that, since this is general contractor, they built this home poorly. It was bad to begin with. So there's no property damage. I'm sure the insureds don't feel that way. So ultimately, what ended up happening was the general contractor had no coverage for the award that the homeowners got against them, which was somewhere in the realm of $500,000 to correct everything, which is not chump change for a small local builder. This one to me screams out as, again, how important it is for contractors to be looking at their policies and making sure that they have amendments to their policies so their carriers can't make these silly arguments, so that they can say, no, my policy says here that faulty workmanship is going to be property damage as an occurrence, unless I subjectively intended to cause the damage or whatever appropriate qualifier, might go in there.
Yeah, I think it's kind of what we talked about at the beginning, setting precedents and understanding the legal landscape. It's so important because while some of these cases, maybe if you're in the audience, you're like, well, that wouldn't apply to my business. They could be cited, like you mentioned. It's up to the court to interpret. So they're going to pull on what's available. So it's just good to be aware of these decisions as it could impact your job in a way that maybe is favorable, maybe not. But if that's the reference, that's kind of what they're going to be going on, right?
Yeah. Yeah.
Well, Theresa, this has been an excellent discussion, and we really appreciate your time and your expertise to speak to our audience about this today. One of the things we like to do on our show is leave our audience with 3 key takeaways. So given the conversation we've had today, what do you think those 3 takeaways should be?
Sure. I mean, I think it's easy. I can break it down sort of per case. First, on your builder's risk, you need to know what the insurance company's tactics are these days, and you need to be prepared to refute them. Be ready for them to trot out the satisfactory state argument, and be prepared to, don't take that line down, essentially.
Mm-hmm.
On the second case about additional insured endorsements, we already sort of said, 2 things. One, think about modifying your contracts to be more specific about what endorsements are and are not acceptable. And 2, review those endorsements, collect them, ask for them with the COI, take a look at them, and make sure that they're going to capture everybody that is required to be added as an AI by contract. And then the third takeaway with respect to the construction defect case is on your own policies, make sure that even in a jurisdiction that has no case law or maybe has good case law, you probably want something that clarifies that faulty work can constitute property damage caused by an occurrence. The taking back of coverage should occur in the exclusions, not in the insuring agreement. So you want to clarify that in your policy.
I think it sounds like perhaps a fourth takeaway is probably have good legal counsel on speed dial just in case,
Oh, yeah.
and to keep them active. But Theresa, what about an action item if our listeners are looking to make a move in the right direction towards some of those solutions? What's the best starting place? What's the first step?
Yeah, I mean, I think the first step has to be with your contracts because all of this flows from your contracts. And if you don't have the right requirements, you can't enforce anything, with your subcontractors, essentially. Or, if you're talking about builder's risk, the owner GC contract should outline some of what's required or what's should be in the policy, those types of things. Start there. Make sure you have the best, most up-to-date language. And then you can go and look at your policies, either builder's risk, GL, or your subcontractor's policies to make sure they meet your expectations and your needs.
Kind of like in a construction sense, it's your foundation, right? You got to have a strong foundation, understand exactly what the requirements are, and you can't really build anything without that. So it's super important.
Definitely.
Well, Theresa, before we let you go, we like to hit our guests with a couple of rapid fire questions, just quick answers.
Okay.
There
We'll
may be
try.
some people out there, some of our listeners thinking, kind of, so what? That this is a legal issue for the lawyers to worry about, which sort of conveniently compartmentalizes that on the back end. How do you see those legal ramifications and I guess maybe the triple up effect back to the project management team that's actually running construction work?
Well, the project management team doesn't need to know all the ins and outs of insurance coverage by far, but they need to know enough to know to loop in their risk manager or their general counsel or their outside coverage counsel. You can't you can't just close your eyes and hope for the best, because that's going to probably result in a huge claim on your company's loss runs. So.
Excellent. Yeah. No, and one thing you said earlier, Theresa, was how long it takes for these cases to get to litigation, to get a resolution. And there's always a chance for appeal. Do you think that any of the cases we talked about today are going to be put to rest for some time, or do you think there may be some appeals that would change these precedents?
Yeah, I think there's a chance in probably all of these situations that they could be overturned on appeal. As far as all three of them go, none of them are from the highest court that they could possibly get to. And if that happens, though, that's going to be a year at least from now. At least, and probably more like 2 to 3 years. A lot of courts are still experiencing backlog from COVID, believe it or not. So the timetable on these appeals is very long.
Right. But all the more reason to stay on top of it, because in the interim, this is the decision
This is the law.
until it's the working decision until
Yep.
otherwise proven. So
Exactly.
yeah, and so today we talked at length about the various notable cases. Is there one in particular that you think would have the most impact on the industry?
Oh yeah, the South Capitol Bridge Builders case, definitely. That's a huge case. The carriers have been really, really going hard on this satisfactory state argument, and they just got smacked with this decision. So I find it hard to believe that it's not going to alter the landscape on a lot of claims.
Yeah, absolutely. Especially with builder's risk being such a prevalent coverage, it's
Absolutely.
on everything, right? You need to always have that. So
Yeah.
Well, Theresa, this is, as you know, this is the Building Byte podcast. That stands for Building Insurance Technology with the Experts, and you are today's expert. So one thing we always like to ask our audience is, or our guests, excuse me, is what are you taking a bite out of today? So you're over in Connecticut. Now we've heard about Pepe's, we've heard about some of these other pizza places.
Yeah.
But where are you going today?
So I'm here to tell you that New Haven pizza is great. But Waterbury, my hometown, is often overlooked. And I used to live around the block from this amazing place called Park Pizza. It's literally abuts a beautiful park, Fulton Park in Waterbury, which was designed by a famous golf course designer. And it is a hole-in-the-wall joint, but the people there are amazing. They're so nice. And the food is incredible. The pizza, my husband and I used to get an extra large pizza, half buffalo chicken, half pepperoni, sausage, and onions for $16. And it was the best pizza I have ever had. I cry. I can't get that where I live now. I cannot. So anytime I'm nearby, I'm going in there for pizza.
As a former, New Jersey resident turned Brooklyn, now in Rhode Island, I understand what you mean. The pizza is not, you can't replace that,
And bagels too, right, Michael?
Yes, absolutely. I don't even try with bagels anymore. I'm just pass, no thank you. No thank you. Exactly.
Well, fantastic. Theresa, thank you for taking time out to chat with us today. If our listeners want to hook up with you after the podcast airs, what's the best way to get a hold of you? Email, LinkedIn, your own podcast, and let us know. How can they get a hold of you?
Yeah, sure. So as you mentioned, I do have my own podcast with my friend Amy Lamb from CR Solutions. It's called Scandals, Insurance Uncovered. And her and I basically talk about the crazy stuff that we see day to day. You can get that on Spotify, Apple Podcasts, or sign up for our newsletter and you'll get it that way. Feel free to email me if you have questions. Guertin, Guertin at sdvlaw.com. I love answering questions and seeing weird policy language people encounter. And I'm on LinkedIn. Just search up my name and you'll find me that way. So, yeah.
Awesome. Well, Theresa, thank you once again. We appreciate you coming on, taking the time. And like Mike said, we'll have to have you back again soon. And we'll see where all these cases are at maybe a few months down the road.
Yeah, great. Thanks, guys. Appreciate it.
Thank you.
Thank you for listening to The Building Bite. This podcast has been brought to you by Proactive. Check us out on thebuildingbite.com, where you can subscribe to our newsletter and follow us on social media for all future The Building Bite news and updates. You can also find us on your favorite apps, including Apple and Google Podcasts, Spotify, Stitcher, TuneIn, and Amazon. If you have ideas for episode topics that we should cover on the show, or you know somebody who would be a perfect guest, let us know at connect@thebuildingbite.com.